is 19024-324. I am Judge Keith Long. Joining me today are Judge Suzanne Brown and Judge Josh Lambert. As a reminder, today's hearing is being recorded, and anything that you say will be posted to OTA's YouTube channel on the internet. Also present today is a stenographer, Ms. Esquivel Parkinson, who is reporting this hearing verbatim. To ensure we have an accurate record, we ask that everyone speaks one at a time and does not speak over each other. Also, speak clearly and loudly. When needed, Ms. Esquivel Parkinson will stop the hearing process and ask for clarification. After the hearing, Ms. Esquivel Parkinson will produce the official hearing transcript, which will be available on the Office of Tax Appeals website. In response to COVID-19, the use of face masks is required during today's hearing. It is important that I and the other members of this panel hear what you have to say, so I ask that you please be mindful of the fact that your mouths are covered while speaking, and I may ask you to speak louder or repeat yourself during this proceeding. With that said, are there any questions before we go on the record? Okay. We are opening the record in the appeal of Furtis Malai Mehrjerdi. The OTA case number is 1904324. This matter is being held before the Office of Tax Appeals. Today's date is Thursday, August 26, 2021, and the time is approximately 10:15 a.m. This hearing is being convened at Sacramento, California. Today's hearing is being heard by a panel of 3 administrative law judges. My name is Keith Long, and I will be the lead administrative law judge. Judge Suzanne Brown and Judge Josh Lambert are the other members of this tax appeals panel. All 3 judges will meet after the hearing and produce a written decision as equal participants. Although the lead judge will conduct the hearing, any judge on this panel may ask questions or otherwise participate to ensure that we have all the information needed to decide this appeal. For the record, will the parties please state their names and who they represent, starting with the representatives for CDTFA.
Chad Backus,
Harry Huxall,
and also Jason Parker, who's sitting in the front row.
Thank you. And for the appellant.
Mitchell Stratford representing Furtis Mehrjerdi. James Dunlap.
Thank you. For preliminary matters, my understanding is that Mr. Casamine, who was originally listed to be a witness, will not be appearing today. Is that correct?
That's correct.
Thank you. And the exhibits for this appeal consist of CDTFA's exhibits numbered A through L. The exhibits were emailed to the parties after the pre-hearing conference. Appellant has not raised any objections to FTV's exhibits. Appellant's exhibits are numbered 1 through 8 and were also emailed to the parties. CDTFA previously objected to admission of Appellant's Exhibit 4. Following a March 4th, 2020 pre-hearing conference, CDTFA's objections were overruled. CDTFA has no other objections to admitting the exhibits identified above. CDTFA, is the summary I just provided accurate?
Yes, it is.
And for the appellant, is the summary I provided accurate?
Yes, it is. I would like to add that we prepared an additional exhibit that's basically a summary of Exhibit 4 that we'd like to discuss during our presentation. I have copies here to distribute.
Okay. We will take 5 minutes for CDTFA to review it, since I presume you did not get a chance to review the exhibit beforehand. And if there are any objections after 5 minutes, we will hear them then. Please go ahead and distribute the exhibits. will go off the record during this time. Are we ready to resume?
The department is ready.
Helen? We'll go back on the record now. Does CDTFA have any objections to proposed Exhibit 9?
CDTFA does object to the admission of proposed Exhibit 9 based on the fact that it was not provided timely, 15 days prior to the date of today. Also, we note that row 6 on this spreadsheet has to do with the case at hand, the issue at hand today, and some of the information is still in dispute.
Thank you. I am going to I am not going to accept Exhibit 9 into evidence, as it is merely a summary of Exhibit 4. The best evidence is the original documentation contained within Exhibit 4. However, you may feel free to refer to this document in your argument. Otherwise, Exhibits A through L, CDTFA Exhibits A through L, and Appellants Exhibits 1 through 8 are admitted into evidence. Next, as confirmed at the August 3rd, 2021 pre-hearing conference, the parties agreed that the assessed deficiency amount is no longer at issue in this appeal. Is that correct, Mr. Dunmore and Mr. Trafford?
That's correct.
There is one issue in this appeal, is whether the notice of determination was issued to the wrong taxpayer and therefore must be canceled. As discussed at the pre-hearing conference, we'll begin with the appellant's opening statements. You'll have approximately 20 minutes. Then CDTFA will be given 30 minutes to make its presentation. Then appellant will be given 10 minutes to make a final statement, and CDTFA 5 for any closing remarks. As a reminder, the members of this panel may ask questions of anyone at any time. Does anyone have any questions before we move on to opening presentations? Excellent. We are ready to proceed with appellant's opening presentation.
Thank you.
Begin whenever you're ready.
The primary issue in this case is whether CDTFA issued the determination to the correct person. In summary, the underlying liability was created by a partnership which operated a gas station in Sebastopol, California. It is well established that a partnership is a distinct and separate person under the law. CDTFA does not dispute that legal principle. There is also no dispute that the liability was created by the partnership and that CDTFA did not issue the liability or the notice of determination to the partnership. Despite CDTFA's clear acknowledgement that the actual taxpayer in this case is the partnership, it claims that it properly issued the determination to appellant as an individual because the seller's permit was incorrectly taken out in her name. That conclusion is not consistent with the related law or CDTFA's own long-standing policy and interpretation. CDTFA attempts to avoid its own policies and procedures in this case by inaccurately claiming that prior cases in which it canceled determinations or portions thereof under the same relevant facts are distinct from the facts in this case. Exhibit 4, which we will discuss later, demonstrates why CDTFA's attempts to distinguish this case from others is misplaced. The relevant facts in this case are consistent with the relevant facts in the cases that we referenced in our brief, which are further summarized in Exhibit 9, which we provided earlier. We will show today that CDTFA was notified of the correct ownership well before it issued the NOD to the appellant. We will show that it even changed the seller's permit from appellant to the partnership for the taxpayer before it issued the NOD to appellant. And we will show that the law and longstanding CDTFA annotations, interpretations, and policy support that the NOD issued to appellant is improper. Ultimately, CDTFA had everything it needed within its knowledge and possession to issue the NOD to the correct person, but it failed to do so. Despite CDTFA claims, there are no facts which excuse its error. With that summary in mind, I will now address the facts which demonstrate that CDTFA was notified of the correct ownership well before the NODs were issued. The notices of determination were issued on February 4, 2011 and on October 29, 2014. Notice to the CDTFA of the correct ownership is evidenced by the BOE 414Z form, which is labeled Assignment Activity History, which we provided as Appellant Exhibit 3, wherein the auditor notes the correct ownership of the business on October 27, 2009, February 3, 2010, March 5, 2010, and July 29, 2010. The auditor also included comments within the audit itself on the 20G3 gas reconciliation and the income tax return schedule, audit schedule 12L. We also provided those as appellant exhibits. Further, the correct ownership of the account is also identified by the principal auditor on April 7th, 2010 in the 414Z comments, as well as on BOE 836, discussion of audit findings form, which is dated October 6, 2010. There are at least 6 separate instances in CDTFA's own files which demonstrate several people within CDTFA recognized that the partnership was the taxpayer, not Appellant. CDTFA correctly identified the correct ownership of the business based on representations made directly to CDTFA by Mr. Ali Kazamini, husband of Appellant and one of the partners, and based on financial documentation provided in connection with the audit activities. As the 414Z comment states, and as Audit Schedule 12L reflects, on the federal income tax return, Schedule C, profit or loss from business for 2007, the revenues and expenses of both Sebastopol Gas Station and Kenwood Gas Station were consolidated on the federal income tax returns. The reason this is relevant is because the Kenwood Gas Station was accurately registered as a married co-ownership with CDTFA. As the auditor recognized, because the revenues and expenses are consolidated on a single income tax return, it is clear that the ownership of both gas stations was the same. Also on the Schedule C, one of the names listed for the partnership is Ali Kazamini, further demonstrating that the business was operated by a partnership, not Appellant, as a sole proprietorship. We included a copy of the 2007 federal income tax return, which is notably the earliest period at issue here, and Audit Schedule 12L, which reflects the same information as the income tax return as Appellant Exhibit 2. Finally, with respect to the income tax returns, we note that there should be no dispute that the income of the 2 gas stations were consolidated, not only because the form itself states that it is for both gas stations, but also because consolidated financial statements were provided to the auditor for both gas stations, which we have provided as Appellant Exhibit 5. The bank statements of the business were also provided to the auditor. The bank statements list the partnership, Mehrjerdi and Ali Kazamini, as the account holders of the business account of Sebastopol Fast Gas. Appellant Exhibit 7 is a sample bank statement from September 2009 to demonstrate this fact. We also included a sample bank statement of the Kenwood Gas Station, which was registered with CDTFA as a partnership. As was the case with the Sebastopol Fast Gas account, the partnership of Mehrjerdi and Ali Kazamini were the account holders for the Kenwood Gas Station as well. Although we provided a single sample statement for each account, the auditor notes that the accounts were jointly held for the entire audit period. At the conclusion of the audit activities and prior to issuing the NOD, CDTFA transferred this business to a separate seller's permit that is held by the partnership. This transfer is a clear and unambiguous action that demonstrates CDTFA knew that the business was owned by the partnership. The bottom line is that the ownership of the business is a well-settled matter based on representations made by Mr. Kazamini, CDTFA's numerous comments which acknowledge the partnership ownership, financial documents of the business which name the partnership, and CDTFA's transfer of the account under a permit held by the partnership that it continues to operate under to this day. We now turn to the legal authority that makes it very clear that the liability issued to Appellant must be canceled. Although audits occasionally result in refunds, audits generally result in deficiency determinations. Revenue and Taxation Code Section 6481, labeled Deficiency Determination, states in pertinent part, if the board is not satisfied with the return or returns of the tax or the amount of tax or other amount required to be paid to the state by any person, it may compute and determine the amount required to be paid upon the basis of the facts contained in the return or returns or upon the basis of any information within its possession or that may come into its possession. Further, Revenue and Taxation Code Section 6486, Notice of Determination, states in pertinent part, the board shall give to the retailer written notice of its determination. Retailer is defined by Revenue and Taxation Code Section 6015 as follows. Retailer includes every seller who makes any retail sales or sales of tangible personal property and every person engaged in the business of making retail sales at auction of tangible personal property owned by the persons or others. Every person engaged in the business of making sales for storage use or other consumption. Seller is defined by Revenue and Taxation Code Section 6014, which states, seller includes every person engaged in the business of selling tangible personal property of a kind that gross receipts from the retail sale of which are required to be included in the measure of the sales tax. Finally, person is defined by Revenue and Taxation Code Section 6005. It states in relevant part, person includes any individual, the appellant in this case is an individual, firm, partnership, who we claim should have been issued the entity, joint venture, limited liability company, association, social club, fraternal organization, corporation, estate trust, business trust, receiver, assignee for the benefit of creditors, trustee, trustee in bankruptcy, syndicate, the United States, this state.
Slow down, please.
I'm sorry. Can you clarify, or would you like me to resume?
The organization.
Okay. Organization, corporation, estate, trust, business trust, receiver, assignee for the benefit of creditors, trustee, trustee in bankruptcy, syndicate, the United States, this state, any county, city and county, municipality, district, or other political subdivision of the state, or any other group or combination acting as a unit. In this case, the person is the partnership of Bertus Mehrjerdi and Lee Casamini. A partnership is a different person than an individual, which is why it is listed separately in Revenue and Taxation Code Section 6005. The partnership is the seller and the retailer. Appellant, who is an individual of the partnership, is not the retailer. The notice of determination was issued to Bertus Mehrjerdi, who is an individual and not the retailer. Because the notice of determination was not issued to the retailer, it is not valid. This analysis related to this issue under law is well known to CDTFA. It is common for the ownership of the business on a seller's permit to be incorrect. The most common example is when an individual incorporates his or her business into a corporation or limited liability company. In those circumstances, CDTFA requires the entity to register for its own seller's permit because it is a different person. The entity permit start date in the context of an audit is backdated to when it began operating the business, and the returns are transferred from the individual seller's permit to the entity seller's permit. The reason this is done is so that the reporting can be attributed to the correct person, and if applicable, a notice of determination can be issued to the right person. This occurrence is common enough that our firm has represented numerous taxpayers whose ownership information on its seller's permit was incorrect at the time that the audit started. We provided 5 examples of CDTFA decisions and recommendations for taxpayers our firm has represented as Exhibit 4, and which we summarized on Exhibit 9. In those cases, the same type of ownership issues were addressed with CDTFA at an appeals conference. In 4 of the 5 examples we presented, the determinations were issued to the correct legal person, but the waiver of limitations were invalid because they were not executed by the correct legal person. And therefore, the determinations were not timely for certain periods. In the 5th example, the CDTFA representative agreed that the notice of determination was issued to the wrong person and recommended that it be canceled. And they subsequently reissued the determination for the periods that were available under the statute of limitations to the correct person. All 5 of the cases underscore the necessity of CDTFA to issue the determination to the correct person, as we contend was not done in this case. The occurrence of this within CDTFA audit activities is also so common that the audit manual addresses how an auditor is supposed to complete a field audit report with the correct ownership. Audit manual section 0202.39, which is titled Owner, states, the taxpayer's legal name must be accurate since determinations issued to the wrong person are invalid. The audit manual also addresses a change in ownership and the transfer of the returns to a new permit. Audit manual section 0219.10 states in relevant part, a new account number must be obtained for the new entity, and the start date of this account should be the effective date of the ownership change. Notably, it does not state that the start date should be on a prospective basis, as was done in this case. CDTFA has even written legal opinions which instruct CDTFA on how to handle the statute of limitations under these scenarios, which resulted in published annotations that we referenced in our briefing. Those annotations are Business Taxes Law Guide annotation 465.1542 and 465.1544. As noted in Yamaha Corp. Versus the State Board of Equalization, long-standing annotations relied upon by CDTFA should be given great weight. In summary, the annotations state that returns filed by the predecessor are to be treated as returns filed by the successor. In this case, the quote-unquote successor is the partnership, since it was the owner of the business. Annotation 465.1544 even states, as is relevant here, that the notice of determination issued in the names of the partnership is not notice of liability owed by the corporation. In this case, the notice of determination to appellant is not notice of liability owed by the partnership. These are CDTFA's own long-standing policy and interpretations. The annotations date back to 1982 and 1996, so this issue is not new by any means. The ownership of a business being incorrect on a seller's permit is common. What is uncommon is that the CDTFA failed to correctly issue the notice of determination to the correct person. In this case, CDTFA needed to issue the notice of determination to the partnership. They did not do that. Instead, they issued the notice of determination to the wrong person, and as a result, the notice of determination that they issued is invalid and must be canceled. Thank you.
Thank you, and I have some questions, and my panel may as well, but I'm going to start. First, with respect to Exhibit 4, do any of the cases in that exhibit discuss a situation in which the appellants request a later closeout date?
They do not.
Okay, and so, relatedly, with respect to CDTFA's Exhibits F and G, it appears that the taxpayer chose not to close out this sole proprietorship until June 30th. Is that in dispute?
The taxpayer did not recall the exact circumstances of the cigarette and tobacco citation and what occurred with that.
Okay. Well, is it your position then that these conversations, which are documented in Exhibits F and G, should have been disregarded by CDTFA?
Our position is absolutely yes, they should have been disregarded. First, I would note that if they issue a citation to the wrong taxpayer, they should reissue the citation to the correct taxpayer and have that taxpayer serve their suspension. For instance, if the account were registered to an unrelated party, certainly the CDTFA would correct that in its record. Second, it has really no bearing on whether or not CDTFA should have issued the notice of determination to the right person. There's just, in our opinion, it just doesn't matter at all. For instance, if the appellant had requested that CDTFA not issue a notice of determination at all, certainly that request would have been completely disregarded. And the issuance of the citation really had nothing to do with the notice of determination being issued to the correct person. They're just really unrelated in our opinion.
Okay, thank you. And I'll open it up to my panel. I will start with Judge Brown. Do you have any questions?
I was going to have questions for the witness, and I don't know whether the representative, whether you have the knowledge to answer the questions. So if
I will to the best of my ability.
right, I understand.
Yeah.
I guess I'm just saying that as a caveat.
Sure.
I wanted to ask the witness about why the partnership didn't notify CDTFA earlier that the co-ownership was operating the business, such as, you know, all of the filings under the sole proprietorship's name and permit. Is there a reason why the partnership decided to continue to have that occur?
I'm sorry, I didn't hear the last part.
Oh, I said, is there a reason why the partnership made that decision? Or was it just lack of understanding about the process?
I believe at the time there was just a lack of understanding regarding the registration for the seller's permit. What I would note is that they did notify CDTFA numerous times prior to the notices of determination being issued. So there was nothing that would have precluded the CDTFA from issuing the correct notice of determination.
For example, Exhibit J, claim for refund.
Bear with me 1 second. Okay, yeah, that was filed by me.
So it was filed under the name of the sole proprietor and that seller's permit. If the partnership, the co-ownership, was the one operating the business, why would they file the claim for refund under the name of the sole proprietorship?
Right. The determination was issued to the sole proprietorship and under that permit number. That's why I filed it under that account number.
I think those are all my questions for now. Thank you.
Thank you, Judge Brown. Judge Lambert, do you have any questions?
This is Judge Lambert. Yeah, I guess just so to clarify, the argument is that the seller's permit, even though it was reported under the sole proprietorship, that these other facts should indicate that we should look beyond what was reported to CDTFA. Is that kind of it?
I'm sorry, I didn't hear the middle part.
Well, the fact that the appellant reported as a sole proprietorship on the seller's permit and held themselves out as a sole proprietorship, that should not be something that we should look at. We should look at other facts that they were, like in reality, not a sole proprietorship. Is that the argument? Or that CDTFA should be aware when it's been reported to them that it's a sole proprietorship?
In general, I would say yes. The CDTFA has an obligation to issue a notice of deficiency determination to the person that actually made the sales. By person, I literally mean the legal person that owned the business. In this case, appellant did not own and operate the business as a proprietorship. The partnership did, and as a result, they should have issued the notice of determination to the partnership. I would say also that, like, in general, like, this isn't really like a disputable thing. Like I mentioned, the audit manual, and there's annotations and such. What generally happens is a proprietor owns a business they incorporate at some point in time. When they get audited, the auditors, their first job is to verify all of the taxpayer information in the system. So not just ownership, but mailing address, telephone number, so forth. If they find out that it's actually owned by like a corporation, what they do is they require the taxpayer to register a new permit and transfer the returns over, and then they issue a bill to the LLC or the corporation that's operating the business. This happens like probably like 20% of audits. It's that common. In this case, it's a little bit tricky in that I think the main reason that the error occurred is because there was a separate permit that was already registered as a partnership. So when they went to do it, they were like, well, we don't need to create a new permit because there's a partnership permit that already exists. We'll just transfer this location over to the partnership. And it's also a little tricky in that it's very difficult for them to transfer the returns from one account to the other in this case because returns already exist for the partnership account. So you can't have like duplicate returns. So what they needed to do was create a separate permit. They can do it either with the taxpayer's compliance, where the taxpayer registers for a partnership permit with the start date, in this case would have been March 22nd, and a closeout date of June 30th, 2010, transfer the returns to the partnership account, issue the determination to the partnership, or if the taxpayer doesn't comply, the CDTFA has the ability to create an arbitrary permit number under the partnership on their own accord without any compliance from the taxpayer, and make sure that they issue the determination to the correct person. So really our position is that the CDTFA has the obligation to issue the notice of determination to the correct person. In this case, the taxpayer was also compliant and that they actively participated in the process. There wasn't any like hiding or anything like that. Obviously the record shows that they noted the correct ownership numerous times.
Okay, thank you very much. That's all I have.
Thank you. And CDTFA, we're ready for your presentation. You have 30 minutes.
Initially, I just want to point out that the department does not recognize a married co-ownership as a partnership. And at one point in time, it did, but subsequently, based on legal guidance, the department stopped recognizing the married co-ownerships as partnerships. And that's evidenced in the department's compliance policy and procedure manual, section 722028, which is regarding the disclosure of confidential information. It states that account numbers for individuals, then parentheses, sole owners, husband, wife, co-ownerships, and domestic partnerships are considered confidential because an individual's account number, when input into the resale verification function on CDTFA's website, would reveal an individual's name and address, which is considered confidential. In the long run, we don't think that necessarily matters one way or the other, but just wanted to point that out for the record. In this appeal, the only dispute is whether the notices of determination were properly issued to appellants. On March 22nd, 2007, appellant opened a seller's permit as a sole proprietorship, operating a gasoline station with a mini-mart, doing business as Sebastopol Fast Gas. Appellant filed sales and use tax returns as a sole proprietor. In 2009, the department conducted an audit of appellant's business. During the audit, the department communicated with appellant's husband, Ali Kazemini, who ran the business operations. On October 27, 2009, the department became aware that appellant and Mr. Kazemini were operating another gas station as a husband and wife co-ownership, doing business as Kenwood Food and Gas. Upon further investigation, the department noted that some of the bank accounts for Sebastopol were jointly held with Kenwood. On February 2nd, 2010, the department informed Mr. Kazemini that the ownership of the business should be changed due to the fact that Kenwood was purchasing fuel for both locations under its account, and appellant and Mr. Kazemini were combining revenues from both locations on Schedule C of Kenwood's federal income tax returns. Appellant then signed a power of attorney form granting Mr. Kazemini authority to act on behalf of appellant in matters with the department. On April 7, 2010, Mr. Kazemini met with the department and signed a statement that appellant's seller's permit would be closed effective March 31st, 2010, and that Sebastopol would be added as a sublocation on Kenwood's permit. That's in Exhibit E. Subsequently, Mr. Kazemini decided that appellant would not close its seller's permit until after appellant served a 20-day suspension of its cigarette and tobacco product retailer license, which is in Exhibit F. On June 28, 2010, Mr. Kazemini stated that the permit should be closed effective June 30, 2010, and that Sebastopol should be added to Kenwood's permit as a sublocation effective July 1st, 2010. That is in Exhibit G. Thereafter, the department made the requested changes. On March 8, 2010, which was during the audit, and prior to the closure of the sole proprietorship seller's permit, appellant signed a waiver of limitations form extending until October 31st, 2010, the time within which the department could issue a determination for the period March 22nd, 2007 through June 30th, 2007. Right, June 30th, 2007. That's in Exhibit H, page 1. On September 23rd, 2010, Mr. Casamini signed an extension to the original waiver, extending the October 31st, 2010 deadline until April 30th, 2011. That's on Exhibit H, page 2. The original waiver and the extension both list appellant's seller's permit number. The department issued a notice of determination to appellant dated February 4th, 2011, and that's in Exhibit C. For the subsequent audit period, appellant's representative signed a waiver of limitations form dated June 14th, 2013, extending until October 31st, 2013, the time within which the department could issue a determination for the period October 1st, 2009 through June 30th, 2010. That's Exhibit I, page 1. Appellant or appellant's representative signed 4 extensions of the original waiver, ultimately extending the October 31st, 2013 deadline to January 31st, 2015. And that's Exhibit I, pages 2 through 4. The original waiver and extensions all list appellant's seller's permit number. The department issued a notice of determination to appellant dated October 29th, 2014, and that's Exhibit D. Pursuant to Revenue and Taxation Code, Section 6487, for taxpayers filing returns on other than an annual basis, a notice of deficiency determination must be mailed within 3 years after the last day of the calendar month following the quarterly period for which the amount is proposed to be determined, or within 3 years after the return is filed, whichever is later. Per Revenue and Taxation Code, Section 6488, a determination is timely if mailed before the expiration of a period for which a written waiver is given. There is no dispute that appellant filed returns for Sebastopol using her seller's permit. There is also no dispute that the department secured waivers of the statute of limitations under appellant's seller's permit. Finally, there is no dispute that the department issued the notices of determination at issue under the same seller's permit. Accordingly, the department timely issued the notices of determination pursuant to the secured waiver of limitations forms. Appellants claim that the department should have issued the notices of determination to the husband and wife co-ownership ignores the evidence and facts of this appeal. Appellant opened her seller's permit as a sole proprietorship in March 2007. At that time, Kenwood had already been operating as a husband and wife co-ownership since January 2006. Appellant could have added Sebastopol to that seller's permit instead of opening her own permit as a sole proprietor, but she did not. Moreover, aside from the revenues of the 2 businesses being combined for purposes of filing federal income tax returns, appellant had not taken any other affirmative steps signifying that she wanted to change business entities. Once Mr. Casamini discussed the potential change with the department in 2010, it was appellant and Mr. Casamini who determined the date the entity should change. The fact that appellant chose to wait to make the entity change until after it served the notice of suspension is proof that appellant did not want the entity to change prior to that date. Appellant's contention that the business entity changed prior to the start of the audit directly contradicts appellant's own request that the change occur at the end of June 2010. Appellant cannot affirmatively request one closeout date during the liability period and then wait until the relevant statute of limitations has passed to assert a different closeout date as a means to avoid the tax liability. Regarding the audit manual sections, appellant references several audit manual sections in Chapter 2. We know that mostly these deal with where there's a question in ownership, and the department believes that there was no question. The appellant, again, affirmatively requested to keep the permit open until the end of June 2010, which is what happened. As for the cases, Appeals Bureau cases cited by appellant in its Exhibit 4, we note that Appeals Bureau decisions have no precedential value, and one decision cannot be used as the basis for the conclusions of a different case. Moreover, the department does not agree that the cases cited by appellant are similar to the appeal at issue. Most notably, the cases cited involve an official change in business entity. For example, a partnership to an LLC, or an LLC to a corporation, or sole proprietorship to a corporation. And those changes occurred prior to the start of the audit period. No such official change happened in this appeal. Also in those cases, once the department became aware of the entity change, the department backdated the start date of the new entity seller's permit to the date of the official entity change. So, whereas in this case, the department and appellant worked together to set the date of the entity change to a later date, in these other cases, generally the change of the entity occurred prior to, and the department and the taxpayer agreed to move the start date of the entity change, or the new seller's permit, to prior to the audit period. Despite completing that step of backdating the seller's permit, the department secured waivers using the predecessor seller's permit number, but issued the NODs to the new entity seller's permit number. Again, this did not happen in this case. This appeal does not follow the same set of facts. Based on the foregoing, the department requests that the appeal be denied. Thank you.
Thank you, and I'd like to open it to my co-panelists. Judge Brown, do you have any questions?
Yes, I may have a question. For CDTFA, I don't recall if you have addressed how the annotations do or do not apply in this case. Maybe you did and I missed it, but the annotations that the appellant is citing.
Right, again, I did not address it in my presentation, but essentially the annotations fall under the same basic purview as the appeals cases, whereas the facts and circumstances presented in those cases are not present in the appeal at issue today. Whereas the department agrees, had the department backdated the seller's permit in this case to March 22nd, 2007, and secured waivers using the sole proprietorship account number, but issued the notice of determination to the husband-wife co-ownership, that would be the same set of facts and circumstances, and we wouldn't be here today. But the fact that the change in ownership to a husband and wife co-ownership, because that happened subsequent to, then then the department believes that the notices of determination were properly issued and the annotations are not on point.
Thank you. I don't have any further questions at this time.
Thank you, Judge Brown. Judge Lambert, do you have any questions?
This is Judge Lambert. Yeah, maybe one question just about, to clarify on Appellant's arguments that the wrong retailer was issued the NOD, and I think what they're arguing is that that the NOD was issued to who was actually, like, in fact, not the retailer, and just maybe you could comment on that, because it seems like if we're going on the seller's permit name, or who's named in the seller's permit, does that some kind of trump everything, or are we actually looking at who is actually the retailer, or under those arguments, interact, or can you comment on their arguments on that matter?
Sure. So, yes, we agree that the seller or the retailer is the one that the department should issue the notice of determination to, that it is the retailer that owes tax based on their gross receipts. Our response, the department's response, is that the sole proprietorship was the retailer. There was no affirmative change prior to June 30th, 2010 that would have changed it. The potential issue in this case is that there's no legal filings required to change to a husband and wife co-ownership, mainly because it is a fiction of the department. There isn't something that you can necessarily, there's no, for lack of a better explanation, if you incorporate a business, there are filings that happen, or if you create an LLC, there are filings official legal filings that happen. And so it's easy to determine the date that happened, that the change happened. For sole proprietorship and a husband-wife co-ownership, there isn't necessarily any legal filings. And so for the department, the fact that the sole proprietorship held the permit and filed returns under that permit and made no indication to the department prior to 2010 that it was not operating the business. The department believes that it was the sole proprietorship that was operating the business and making retail sales.
And the appellant continued to state during the appeals process, during the audit, that the sole proprietor was the retailer by requesting that the seller's permit number not be changed until June 30th, 2010. Mr. Casamini, who was the husband in the husband and wife co-ownership, said to the department that the business was operating as a sole proprietorship and should continue to do so until June 30th, 2010 by requesting that that permit number stay open until then. So, and they continued to sign waivers under that seller's permit number. Petitioner or appellant's representatives continued to sign waivers under that seller's permit number, asserting that they were operating as a sole proprietorship through those dates.
Thank you very much. I think I got it. Thank you.
Thank you, and I have no questions. So we will turn it over to appellant, who has 10 minutes to make a rebuttal. You may begin when you're ready.
Okay. So first, we'd like to dispute some things that the department is saying are facts. At no point did Ali Casamini state that the business was owned by his wife as the proprietor. He merely requested that the cigarette suspension be carried out. And it's not even clear that he made that request or that the department did that unilaterally without Also, the sole proprietor was not the retailer during the periods that are issued here. That's clear by the evidence that we presented. The bank statements, the income tax returns clearly show that the business was operated by a partnership. And a partnership is a distinct legal person from a sole proprietor. There doesn't need to be a Secretary of State filing for that to be true. It's why they're listed as different persons in Revenue and Taxation Code Section 6005. As far as the waivers of limitation that were executed or various communications, first of all, we note that all the waivers are invalid. The department was put on notice of the actual ownership of the business. If the notices of determination had been issued to the correct legal person, we would be here talking about how certain periods need to be canceled because the statute of limitations wasn't properly extended. The reason that the appeals cases are relevant is that CDTFA actually issued the NOD to the right person in those cases. So only the periods that were expired under the statute of limitations, because the waivers were invalidly executed, were canceled. So they did more right in those cases than they did in this one, where they couldn't even issue the determination to the right person. And even one of the examples we provided, they did issue it to the wrong person, and they subsequently canceled it. The real issue is just who was the retailer during these periods, who was liable for the tax. CDTFA has to issue a notice of determination to that person. They were notified ad nauseum in this case, and the evidence supports who the true retailer was. CDTFA states that they stopped recognizing the different married co-ownership, but seems like more has to do with disclosure of residential addresses than an actual distinction in the law between a partnership and an individual. Further, if there was no difference, it's unclear to me why the auditor would comment 4 different times that the permit needs to be changed, or why they would transfer the permit to the married co-ownership at the conclusion of the audit in the first place, if the distinction isn't relevant. Obviously, the distinction is extremely relevant in our opinion. So for us, a lot of this, even the cigarette citation or the waivers of limitation, or even the similar cases we provided, they're all kind of don't matter that much. The basic fact is the retailer is the person who must be issued the NOD. The retailer was the partnership, which is supported by the evidence. The department was put on notice of the correct ownership of the business, and they failed to issue the notice of determination to the right person. Because it was issued to the wrong person, it has to be canceled. Thank you.
Thank you, and I'd like to ask my co-panelists if they have any questions. Judge Brown?
I don't have any questions, further questions, thank you.
Judge Lambert, do you have any questions?
No questions, thanks.
Thank you. And CDTFA, you have 5 minutes to make any closing remarks.
Thank you. We'll just point out that in Exhibit H, the note there states that taxpayer requested the change, whether that was, I'm assuming that was appellant and not Mr. Casamini who requested that the date of the closeout of the permit be changed to the end of June. And also we wanted to point out that the department, the auditor, came to the conclusion based on the evidence that perhaps the entity should change to be under the Kenwood permit. It wasn't anything that appellant or Mr. Casamini came forward and told the department to make the change. The department came to them, to appellant Mr. Casamini, and suggested it. And again, it was appellant and or Mr. Casamini who determined when that change should happen. had they requested the change happen and in 2007, then that's when it would have changed. That's when the department would have made the change. It would have backdated it. The fact that appellant did not request that to happen, but instead requested the change to happen in June 2010 is the one determining factor on how this case should be decided. And again, those were affirmative steps and requests by appellant for the change to happen at that time. So until their requested change, it was appellant that was making retail sales, and it was appellant that owed the tax. The waivers were secured using that permit number, and then the notices of determination were issued to that permit number. So those are valid, and they should be sustained. Thank you.
Thank you. Judge Brown, do you have any questions?
I don't have any further questions, thank you.
And Judge Lambert, do you have any questions?
No questions, thanks.
Okay, thank you. Mr. Stratford and Mr. Dunler, we've heard your presentation and argument this morning. Do you have any final remarks before we conclude our hearing?
I do have one final remark. Department appears to rely on appellant's request. Appellant is requesting that this determination be canceled, so we'd like them to grant the appellant's request. Thank you.
Thank you. We're ready to conclude this hearing. Is the panel ready to close this appeal? This case is submitted on Thursday, August 26, 2021. The record is now closed. Thank you everyone for coming in today. The judges will meet and decide your case later on, and we will send you a written opinion of our decision within 100 days after the record is closed, or within 100 days from today. Today's hearing, the appeal of Furtis Mehrjerdi is now adjourned. This concludes all of the oral hearing matters scheduled for this morning. Thank you.
Thank you.
Thank you.